Yes, Lord.
What is the date?
Date, my Lord. But sorry, my Lord. 1976, 77. Not 78, 70. 76, 77.
In the year 19?
76, 70.
76?
77.
Yes, sir.
But since no 9C and 3B was no compensation has been given to the petitioners. Never university comes straight away. When not come, this is the third time I have come. The petition has come. But I not come. Page 27.
Page number 27.
Yes. A challenge was the pursuant to order of this Honorable Court, the representation has been disposed of. They have awarded no compensation. I have challenged that order. Now we're going to see first, my Lord, page 27. So Gairam Sapu is not here, my Lord. There are so many petitioners.
Page number 27 is the order date 21/11/2019.
Yes.
Yes. What happened there?
Made a representation such and such to the district such and such.
Consider the aforementioned represents strictly in accordance with law.
Representation has not been considered. Consider the subject of the petitioner that it is disposed of. By request to the respondent to consider representation strictly in accordance with law. Then we can see next page.
Yes.
Can you see, my Lord? Pursuant to that order, the authority concerned passed the order. Order number 3.
Page number
29. Order dated 18 February 2020.
Yes.
Today, representation of the requiring body, that is PWD Road, as well as the representation of present today, filed Hajira Sadan Sai. Verified the representative petitioner, dated 8 January 2018 and 1st February 2018.
Then
Which were found annexed with the writ petition, it appears from the contents of the same that the petitioners are claiming compensation of the right to fair compensation or transfer in such and such 2013 and or in other words new act for acquisition of the land in education number such and such. But it is wrong. It will be 76, 77. Subsequently, they have corrected. In this regard, it needs to mention that the Honorable Supreme Court of India by an order such SLP such and such, Pune development is quoted, taking all its into consideration, we are of the opinion that it would be appropriate if the interim and pending final decision on making a reference at all a larger bench, the High Court be requested not to deal with cases relating to the interpretation or concerning Section 24 of the Right to Fair Compensation Act 2013. The Secretary General will urgently communicate this order to the Registrar General of every High Court so that our request is complied with. In so far as the case pending in this case are concerned, we requested the concerned benches dealing with the similar matters to defer the hearing until the decision is rendered on one or the other, or on the issue whether the matters should be referred to larger bench or not. Apart from anything else, deferring the constitution would avoid inconvenience to the litigating parties, also whether it is such and such. Under that line was quoted, under the above facts and circumstances and in view of the valued observation expressed by the Honorable Supreme Court of India, as stated above, since the prior of payment of compensation was made under the new Act 2013, which is pending for consideration before the Honorable Supreme Court, thus understand is unable to pass any order. Then, my Lord, again I came. Next page. 31.
wait, sir, wait. Page number 29, 30 is then reason order.
Yes.
Reason order dated.
No order was passed. That's kept
Either has it mean?
Yes.
No, cases are disposed of.
Case is disposed of.
Order has been passed.
Consider and set aside.
18 to 2020.
No, sorry, subsequent. Hence, the representation of the petitioner is considered and set aside. Last portion.
Yes.
Set aside.
So this representation disposed of.
Disposed of.
That I said.
Then I challenge that one.
You again challenge that order.
Next page.
Page number 31.
31.
That is the order dated
Third, not a council.
14th March 2022.
Yes. It is submitted on behalf of the petitioner that pursuant to the direction of this court, the petitioner submitted to the concerned authorities for payment of compensation in lieu of acquisition of land by an order dated 18 February 2020. The concerned authority being the district collectors of South set aside and dispose of the representation of the petitioner with an observation that the payer for payment of compensation, the right to pay compensation in land acquisition Resettlement Act 2013 is pending for consideration before the Honorable Supreme Court. Our authority is to consider the representation of the reason. It is on behalf of the submitted on behalf of the parties that a matter has been addressed by judgment of the Honorable Supreme Court. The petitioners pray for direction upon the authority for consideration of the representation submitted by the petitioner. In view of the same, the writ petition is disposed of, directing the second respondent.
No, Mr. Bhattacharya, what is the second paragraph? It is
It is
submitted on behalf of the parties that the matter has been set at rest. Oh, so it has been disposed of then.
Disposed of.
Very good. Then,
in view of the same, the writ petition is disposed of by directing the second
to
respondent
reconsider the representation.
before the
And the disposal.
Next, third paragraph.
Uh-huh.
As the petitioner interested in direct purchase of the property in question by the state respondent in terms of memorandum of such and such, date 25th February 2026, the concerned authority may consider the said proposal of the petitioner in terms of the memorandum dated 25th February.
So government will make a direct purchase.
Direct purchase.
Government.
No.
State.
We agree for direct purchase. If the direct purchase policy that they introduced, we agree to.
No, the government has introduced a direct purchase scheme.
Yes.
To which you are agreeable.
Agree.
Very good. Then what happens?
2013 Act. As a question.
Very good. Then
That order was passed. That was disposed of. Then, my lord.
Page number 31 to 33.
The next page. Some persons, either my lord or similar situated candidates, they file an application in or dispose of matter. I am also interested because I am the owner of the sum of the co-sharer. The same order may be that order may be benefit of the order may be extended to us also. On their application, my lord, can 1 of 2020. They are not.
So the honorable court permitted
Yes.
also the second respondent to consider their
Yes,
representation also.
Yes.
That I have seen.
They are not before your lordship. No.
Say on the basis of a can.
Can.
Is that required for the purpose of the instant writ petition?
No.
Very good, sir.
Then, my lord, pursuant to that order, then authority.
First, which order?
Page 37. This order. Second order.
That is under challenge before this court.
No.
That is also
Consider the dispose of the our representation.
page number 37 to
37.
no. Where is the operating part? 10 to page number 40.
Yes, my lord. I'm telling.
Page number 40, sir.
40.
40.
40.
Order dated 10 to 2020.
Yes.
Order dated 10 to 23. Yes, sir. Kindly place.
Yes, sir. The case record is taken up today for hearing as scheduled. All
No. Read from the relevant part, sir.
relevant.
41. Come to page number 40.
But back to that, your also can you see
No, the representation of the
last
representative
paragraph,
or
the
applicant.
petitioner, as Anisha is not scheduled, the representation the representative claim.
You are reading which portion?
Last portion, page 40, last portion.
Page 40.
Page 40, last paragraph.
Yes, sir. Please place.
The representation of the writ petition and the writ application as there is with the writ petition are scheduled. The writ petition in the representation claim that compensation may be given under right fair compensation act such and such. The next page. against acquisition, or as per direct purchase. It has been
As either as per 2013 Act
direct purchase.
or as per direct purchase policy. Very good.
Yes.
Then
Second paragraph. The order or constitution bench of the Honorable Supreme Court of India dated 6 March 2020 passed in express such and such is a matter of Indian development. It reveals from paragraph 363 of clause 2 of the said order of Honorable Supreme Court of India, in case the award passed within the window period of 5 years, excluding the period covered by an interim order of the court, the proceedings shall continue as provided under section 24(1)(b) of the new Act, as if it has not been repealed. But award
if the
passed,
award has been passed within the window period of 5 years,
yes,
excluding the period covered by an interim order, then proceedings shall continue
on
as provided in section under new Act under Act. It is under Act 1 of 1894,
yes,
as if it has not been repeated.
yes.
Very
Then
good.
on verification of the records of education of such and such, it appears that award was prepared. But can you mark it? Not passed, prepared. That is not the same. No, I can show you judgment, our High Court judgment. Prepared. Under section 11 of Act 1, after receiving notice under section 93B, was duly vetted by the government on 16 June 2011. Hence, the instant proceeding will have to be dealt with and concluding the right of the above Supreme Court of India, such and such. The details of the award passed by the decision director against each of the institution funded below.
এই আমাকে না 2013 একটা আর 1894 টা এখানে আছে বোধহয় এইটার মধ্যে একটা বার করতে হবে। Yes, then what happened? They made a calculation.
Yes. Then next page, my lord.
Award.
Award. The means of first, second, Jyotish Haldar, he is the petitioner one here.
Yes.
5, Mukund Haldar, petitioner 2 herein. 6, Nikhil Haldar, petitioner 3 herein. 4, Monmoto Guide 7 is a court hearing. And petitioner 5, Pakto Sarati 8 is 5 hearing. Then, my lord, where is it? Take Jyotish. 4418. Fraud. Fraud number is requisition such and such, possessions taken by the recording body, utilized, but not.
You are reading which portion, Mr. Bhattacharya?
Jyotish Haldar.
Jyotish Haldar, I've got it. Then?
Jyotish Haldar, plot number 4418. 42.
Huh?
Page 42.
I am on page number 42. I got Jyotish Haldar. Wherefrom will get the plot number?
4418. 4418.
4418. Yes, yes, I got it.
Award.
4418. Yes.
Fraud is requisition under section 3(1) or 2. Possession taken by the recording body and utilized but not published in Gazette notification under section 4 such and such. Letter. The fraud is neither included in the list of 93B notice nor award is declared in the name of the petitioner. Mark it. Then,
Possession taken by the requiring body, utilized but not published in the Gazette notification under section 41A. Later, the plot is neither included in the list of 93B nor award is. So it has been materially utilized.
Utilized. What is that different? Acquisition and utilized. Now they are taking a stand now. Nowadays I find they will get compensation of the utilized. Suppose 20 decimal was acquired. Now they say no. Since the 10 decimal has been utilized, you will get compensation of 10 decimal. Why?
Just a minute, sir.
Wait a minute.
1948 তো হলো Mr. Bhattacharya,
Yes, sir.
plot is requisition under section 3(1) of Act 2 of 1948. That I have understood.
Yes,
Possession taken by the requiring body, that I have understood.
yes,
And utilized, that I have understood. But not published in the Gazette notification under section 4(1)(a).
yes.
It means acquisition has not been completed. But later, the plot is neither included in the list of 9(3)(b) notice.
Yes.
9(3)(b) under Act 1 of 1948.
9(3)(p) is because after
9(3)(b) of which Act?
9(3)(p) that Act 2 that was repealed 1997. Then after 9(3)(a) and 3(b) comes, my lord. 9(3) and 9(3)(p). I am reading the 9(3) and 9(3).
9(3)(b) of which Act?
Act 1. Act 1.
Act 1, that I'm saying.
I am reading that. Act 1.
9(3)(b). Just a minute, sir.
I am reading, my lord. The collector.
Wait, sir. Wait. Give me a second, sir. 9(3).
9(3)(a), 3(b).
3(b) to.
After dashing on 9.
Yes, sir.
The collector shall also serve notice to the same effect on all such persons known or believed to be the interested in land or to be entitled to act for person so interested possession whereof has already been taken on requisition under section 3 of the West Bengal Land Acquisition Act 1948. Herein after refer to the section I said that as enacted by the West Bengal Land Requisition and Acquisition the Enacting Act 1977, and in every such case the provision of subsection 1 of section 4, section 5 and section 5(a), section 6, section 7 and section 8 of this act shall be deemed to have been complied with.
Mr. Bhattacharya, just a minute. The collector also sorry, yes, sir. So, Mr. Bhattacharya, 9(3)(b) presupposes requisition and acquisition.
Requisition.
Am I correct?
Yes.
9(3)(b) presupposes requisition under section 3 of the 1948 Act and acquisition under section 4(1)(a) of the 1948 Act.
Okay.
Thereafter, the 9(3)(b) 9(3)(b) come of the 1894 Act come into play.
Yes.
Now here they say not publish the Gazette notification under section 4(1)(a) of Act 2. Later the plot is neither included in the 9(3)(b) notice nor award is declared rightly.
But not published in Gazette of such and such.
Unless it has been acquired under section 4(1)(a), it will not be 9(3)(b) will not apply. Naturally, rightly done.
Yes, not be applied. If it's not applied, then I'm entitled to get benefit of 2013 Act. I can show to your lawsuit.
That you want to say.
I shall get it. I'm entitled, my lord. That is my submission. Now, there stand the award was passed by how?
So for the present, you are concerned with 4418, 71, but
418.
only.
I'm coming.
Very good.
Then,
Then,
my lord, why? Mukundu Havdar. Plot, award, amount, such and such. Here, the award has been passed or not, nothing. No award.
huh?
Then, this plot, Mukundu Havdar.
Huh?
This petition 2. Plot number such and such. An area. Award number such and such. This amount, only amount. Remark, nothing.
So what have you got to say with regard to Mukundo?
They have not mentioned because only this area award number such and such award.
Hmm.
Award when award was passed, nothing has not been mentioned. But I am submitting now because
No, the quantum of
amount
award is
Which
there.
the award has not been passed. If it is not
Quantum of
mentioned,
award is there.
quantum of award is there.
Huh.
Quantum of award is there.
Huh.
Under which act award has been passed? Now I am coming, well. Under which act? There was no 41A notice was served upon my client. There were not 6. Nikhil Haldar. Plot of such and such. Award 260. Amount such and such. Award is prepared in his father's name only. Award is prepared. Remark. Then 4 and 7. Monmoto. Plot number 4288. Award was not made in the name of the listener, but in favor of other person. Then 5, this plot is not acquired and his award has not been declared.
Then how you are aggrieved that? Please tell me that.
In some portion, no award has been passed. In case of some of the petitioner.
Huh.
Next page, you will also kindly see. Next page come. Now, starting from now. Now, as regards the claim of the deed petitioner 2, namely Jyotish Haldar, the petitioner 1 here, that is, it appears that no award was declared in his name. Against this claim, suit plot number 4418, measuring the area such and such. Though the said plot was found requisition under section 3(1) of the original land requisition chapter 948, and possession of the plot was taken over by the requiring body on 30th April 1976. It also reveals that neither the said plot was acquired under section 41A nor any notice was issued under the 950 of the land requisition such. For reviver of LA case, for joint field inquiry report dated 30th May 2022, it also appears the said plot has already been utilized by the requiring bid for construction of the road. Then you will also find the last paragraph. In view of the above finding as derived from the existing official record, it is thus concluded that as per order of the Supreme Court, in the matter of inter development, the LA proceedings are treated as not lax, and all the above eligible requisition are entitled to get their compensation in accordance with the award passed against their names with respect to their constant food plot as per statute, except plot number 4418, of requisition number 2 and plot number such and such. The award in respect to food plot number 4418 is to be declared in the 2 and award in respect such will not be declared. Here, my lord, you also can see, can you mark it? Award. Now we have in accordance the award passed. Award passed.
Award passed in respect of whom?
Award. Award passed. Award prepared. I can show. No. If it is passed, it does not mean the award has been prepared. When award that in the I have read, my lord, in the year 2000, now it appears from the order, the award was passed in the year 2011.
No, Mr. Bhattacharya, what is your grievance? Kindly tell me.
My grievance because last 40 years I have not concluded that ordering process.
Yes, sir. So they have accepted that in respect of plot number 4418, which stood recorded in the name of Jyotish Haldar, award has not yet been declared.
With regard to plot number, plot number, I'm saying they have stated which plot has been acquired, the prepared award such and such. Under which act I am the award has been passed and I have my client, the petitioner will get compensation under which act? The one kindly see last portion, last order, page 47.
47.
47. 47.
Hmm.
Last line. Last paragraph. Hence the representation of all applicants, because all the applicants are not DPO lawsuit, and the writ petitioner are hereby considered and disposed of in compliance of the order dated such and such, First Bengal High Court. It is our grievance, my lord. Our grievance is, my lord, low compensation has been awarded. Low compensation.
No compensation has been awarded
Because the award has been passed under the old act. But
in respect of which petitioners?
both the all petitions, 5 petitions. All the petitions
No.
that is are not legal lawsuit.
But one petition was moved to WPA number 1432.
Yes,
One Niranjan Sapui was the first writ petitioner. Petitioners were there, my lord.
I have that.
বলছি তো তুমি তো বলোনি my lord. Niranjan Sapui was the first writ petitioner in WPF 1432. Petitioner was there, my lord, as a petitioner in compliance, and the order passed by this honorable court on 14th March 2020. And in compliance of that order, my lord, the district magistrate was directed to hear the matter and reconsider their applicable representation. Accordingly, the district magistrate heard the matter and passed the reasoned order, that is annexed P6 to the writ petition. Order passed on 10th
My
February
no
2020.
compensation is complete with it.
হ্যাঁ।
করতে থাকো।
ক্লিয়ার করে দাও তাই বল তুমি বলো
But I've challenged that order, the low compensation has been awarded. Low compensation.
No compensation has been awarded in respect of whom?
All the petitions, the petition before lawsuit, 5. Not correct.
1, 2, 3, 4, 5.
Yes,
But they have stated, so far Jyoti Jaldar I have understood.
yes.
But so far as Mukundo Haldar is concerned, award has been deferred.
Yes, because only 20 page number 42.
Huh.
Page number 42.
Award has been passed.
Under which act? Act, old act. Now they are saying in 2011, award has been passed. We are not award, madam. Award has been passed. That is the old act. Madam, that is
Old
the
act means which act, sir?
act 1.
So what is the wrong in it?
It's a wrong order. One kindly see the order, second order. In the second order, the one I am submitting order, page 32. That order was passed in page the running accident for the state.
No, sir. Let us take one by one. So far as Mukundo Haldar is concerned,
Award,
awarded amount is 24,475.
Yes.
So where is the wrong in it? That I intend to know.
they have not mentioned. Now they are saying award has been passed in the year 2011. Because prior to 2013 Act came into effect.
Prior to?
2013 Act came into effect.
Huh.
That is there on these lines. They are dispose of our representation. Now I am saying.
No, where they have stated that I
They have not
intend.
stated. Only stated, Mala, kind of see. Stop. Stop. They have stated, Mala, kind of see. Page 40. Page 40. Rosemont land acquisition structure on 30th April 1976. The plot was for a requisition and possession was delivered to the requiring body PWD on 3rd May 1976, followed by Gazette Notice under section 4(1)A published on 8 March 1979. Filed order number such and such. It is 3rd August 1978. Said land acquisition proceeding could not be proceeded further. Subsequently, LA case was revived by issuing notice 9CB on 4th August 2010, and award was prepared on 21st.
You are reading which portion, Mr. Bhattacharya?
Page 40.
Which portion? Page 40, I am there.
It's a kindly come page 39 first.
Yes, on thorough verification.
Thorough verification of the available office record, it transferred the full brief plots mentioned above were proposed for acquisition, education about such and such. issuing requisition order under section 3(1) of
Yes.
the West Bengal Land Requisition Acquisition Act 1948
Huh.
on 30th April 1976, and possession was delivered to the recording body PWD
Yes.
on 3rd May 1976, followed by Gazette Notice under section 4(1)A published on 8th March 1979
Very good.
by number Satyan sir, dated 3rd August 1978. Said land acquisition proceeding could not be proceeded further. Subsequently, the LA case were revived by issuing notice under section 3B on 4th August 2010. And mark it. Award was prepared.
On 21/6/2011.
Award was prepared on 21st June 2011. But LA proceeding could not be completed due to non-placement of the fund by the recording body.
Just a minute, sir. Just a minute. Please stop here.
Therefore, that means what the award was prepared, but does not tantamount to declaration or making award.
Yes, Mr. Acharya Chattopadhyay.
My service of before also my lord, award prepared, but not tantamount, does not tantamount to declaration or making award. That is my submission.
Then come to section 11 and section 12.
Act 1.
Yes.
Yes. Section 11.
Yes.
On the day so fixed, Act 1,
Yes.
or on other day to which the inquiry has been adjourned, the collector shall proceed to inquire into the objection, if any, which any person interested has stated, pursuant to a notice giving under section 9 to the measurement made under section 8, and into the value of the land at the date of publication of the code at subsection 1, or into the respective interest of the person claiming the compensation shall make an award under this, under his hand of such and such, provided that no award shall be made by the collector under this subsection without previous appropriate government or of such officer as the appropriate government may authorize in this behalf. But myself here, any notice 441 notice has been served upon the petitioner? No. It repeats no notice under section 441 has been served. Then when provided further it shall be competent for the appropriate government to direct that the collector may make such award without such approval in such case of cases as the appropriate government may specify in this behalf. 2. Notwithstanding anything contained in subsection 1, if at any stage of the proceeding the collector is satisfied that all the persons interested in the hand who appeared before him have agreed in writing on the matters to be included in the award of the collector in the form prescribed by rule made by the appropriate government, he may, without making further inquiry, make an award according to the terms of such agreement. The determination of compensation of Indian land or subsection 2 shall not in any way affect the determination of compensation in respect of other land, such and such, of this act.
Now come to 12.
12. Award of collector when to be final. Such award shall be made in the collector office and shall, except as have been provided, be final and conclusive evidence as between the collector and the person interested, whether they have respectively appeared before the collector or not, of the true area and value of the land and the appropriate of the compensation among the.
So 11, 12 complied with.
Yes.
11, 12 complied with. 11 and 12 complied with.
11 and 12 complied with. But 418 notice has been served upon me. First 418 notice has to be served.
No. 4-1, your acquisition proceeding was started under Act 2 of 1948.
Act 2.
Then 9(3)(b) will apply.
Act 2. Act 2, that will repeat 1997. That was therefore 9(3)(a) and 9(3)(b) come. That notice is to be served within 1 year.
Which one?
9(3)(a), 9(3)(b).
Yes.
What that notice? Nothing. No notice has been served upon any of the petitioners. I'm reading I shall read the order again.
No, sir. What I intend to know, your acquisition proceeding was started under Act 2 of 1948.
Act 2 1948.
Now, 9(3)(a) and 3(b) has been complied with or not?
No. That has not been complied with. The next page, page 40, now it has appeared that 41A published on 8 March 1979 and 93B notice was by issuing notice on 4th August 2010. Upon whom notice has been served. That is my submission report also. They have final report also.
No, where from will get, because it has been stated that subsequently LA was revived by issuing a notice under section 93B.
93B.
Yes,
That notice should be served.
it has been served, it is the finding.
That is the finding. My submission, no notice has been served upon us.
So
They have
what
not- in my
material
repetition-
has been given?
In my repetition, they have not used any affidavit of opposition. Only the submitted report.
That there is no such detection for affidavit. If your lordship direct, we shall file affidavit.
That's not yet filed an affidavit.
We shall file my affidavit in
Yes.
opposition. Your lordship direct me, we shall file my within 7.
No.
They have not denied it.
In the event,
There is
9,
no such direction.
no,
only
Mr.
direction.
Bandyopadhyay, so far I have understood, in the event it is your case that 93B
Well,
has been
in
complied
respect
with.
of all land, it was not done. Madam.
Yeah.
His claim is only in respect of plot number 4418.
That I am saying, that I am
Yes.
doing.
In respect of plot number
No.
4418. No.
I have mentioned all the petitions.
No.
Every petition, 5 petitions are there.
I shall
Then
show
I
before
agree.
your lordship, let him complete.
Mr.
Let him complete.
Sir, Mr. Bhattacharya, what I'm on, so far as the other plots are concerned, it is the finding of the authority that 93B has been complied with.
Now there stand, this is the order, there stand, I have challenged the entire order. For the 5 petitioners, they have challenged the order.
If 93B is concerned, then we are to abide by the
Yes,
provisions
I
of
have understood. I have understood.
understood. We are to abide by the Act 1 of 1894. That is 11 and 12.
Yes.
11 and 12.
When my subject has any service of notice, I have stated the reason.
Service of which notice?
Service of, yes.
Service of which notice?
What is the side 3A and 3B?
3B notice.
We shall file affidavit in opposition. The lordship direct.
They have issued.
file affidavit.
Upon whom?
ঠিক আছে আমরা affidavit দেবো।
Yes.
আমি দেবো।
No, is it your case that without serving 93B notice,
Yes.
the collector proceeded under section 11 and made the award?
Yes.
What is your pleading to that effect? What is your pleading to that effect?
Just it. Most of it is there. Yes, there. Paragraph 16.
1/6.
Yes. 15, 16, 17. 17.
Please, sir.
Paragraph
Please.
17. Paragraph page 6, paragraph 17.
Yes.
The possession of the subject was taken of the land of issuing the or the respondent did not issue any
No
action.
notice under section 3A.
No notice under section 9.
Yes, it is there. It is there.
Was served upon the petitioner. In paragraph 17.
So practically then you want to get the benefit of section 24 of the Act 30.
Yes. That is why
Section
not the
24 of the Act 30 of 2013.
13.
You
Yes.
want that benefit.
But I can show that our High Court judgment.
Yes, Mr.
Don't tell
Bandyopadhyay.
me
What is your contention?
My lord, you shall file affidavit if his contention is when we have not served any notice. Notice has not been served, not complied the provisions of the 93B. We shall file my affidavit by annexing all the documents. The lordship direct.
Just now I can cite one judgment. Our High
No,
Court
no.
No, I-
No, no.
Let-
It is already
Yeah,
been completed.
let me understand
judgment.
the facts. Let me understand the correct facts.
Yes.
Your contention, so far I have understood that in respect of one plot,
Yes.
no notice has been some, that has been
In
declared.
respect of 4418.
All petitioner because channel no
No,
Mr.
no.
Bhattacharya,
Yes.
try to understand what I am saying.
Yes, yes.
I believe they have admitted that in respect of 441, that is Jyotish,
Okay.
in respect of Mr. Jyotish, no notice was served. So practically new act will apply.
No award has
No award has been
Here,
passed.
award.
here before the manner the coordinate rate, direct purchase. As your lordship, my lord,
Yes, I've
appears
seen.
of the order.
But so far the other petitioners are
Next
concerned.
to your lordship, see.
They have stated that the proceeding has been concluded after service of notice under section 93B.
Not-
Therefore, and an award has been prepared under section
Prepared and declared, my lord.
declared under section 11.
No, no,
Yes.
not just that. No, I am submitting, my lord, yes. So far the
Yes.
other petition is concerned, award has been passed. But now,
Let them file the affidavit of opposition.
because I,
How much time required, Mr. Bandyopadhyay?
but award
Three
has been part of old act.
3 weeks.
3 weeks.
My lord.
Achha. After hearing the learned advocates for the contending parties, it appears to this court that the instant petition is required to be heard upon exchange of affidavits. Stop para. In view of such, the respondent state and its functionaries are directed to file affidavit in opposition within 3 weeks hence, after serving an advance copy of the same to the learned advocate on record for the petitioner. Stop para. Affidavit in reply, if there may be, is to be served within 1 week thereafter.
My opinion reply 1 week, but 2 weeks you can be.
2 weeks thereafter. Let the matter be listed in the let the matter be listed under the same heading on August 29, 2025.
I can hand over a judgment, but I can other day when
আমরা
I
পরদিন আজকে ভুলে যাও,
By
সব
two.
ভুলে যাও, আমরা ভুলে
Let the pleadings are complete.
now there is a report they have submitted.
No,
They have-
Mr. Bhattacharya, if it is noticed that 93B notice has been complied with,
Yes.
an award has been passed, then you don't have any case under section 24 of the new act,
Yes.
except the case of Jyotish. Jyotish may
All.
other 2 or 3 petitioners, their lands, my lord, 1 or 2 plots, 7156 or 71566.
They have passed
That
award.
are- that are-
Four
that
petitions
declared
concerned.
that satisfy me.
That
Only
award
2 or 3 plots.
One award has been done under the old act. That is my given to your lordship.
Very good. Satisfied.
But it will be monthly stuff.
No, not 29th August.
20 ago.
But I appear for the petitioner. Extremely sorry for appearing virtually. But what has happened, this is in regard to a water body.
But
Just a minute, sir.
I appear on behalf of the state respondent, my lord. I'm being led by Mr. Owen Banerjee, my lord.
Where is Mr. Banerjee?
My lord, he was logged in virtually, my lord, I'm told. And my lord, before my lord proceeds, my lord, I would wish to point out something, my lord. On the last occasion, my lord, though I was not present, my lord had directed the state respondents to file the report in the form of an affidavit. My lord, I have got the copies of the report, my lord, dating back, my lord, to the year 2023. As well as, my lord, there are 3 copies of the reports which had been prepared by the police, my lord, of the respective concerned jurisdictional police station. As well as, my lord, I have a copy of the report of the learned ADM with me. But my lord, the impediment was that the affidavit could not be found, my lord. So I was beseeching, my lord, if my lord kindly grants me 2 weeks time, then I will prepare a comprehensive report under affidavit and submit before your lordship. Because I'm carrying all this with me, my lord. My lord, prior to my lord hearing this matter, when the other learned judges who were in session of the matter, my lord, we had tried to file the report there.
Give me a second.
Yes, my lord.
For the private respondent number 9.
My lord, the private respondents are not being represented, my lord.
They are not here, my lord. There was a direction for filing of affidavits as early as 16th October 2023, my lord.
Yes, my
And
lord.
there's an interim order passed on that date, which is being actively violated by the private respondent in active collusion with the state police authorities and the land authorities, my lord. There's an that is the grievance, my lord.
But there was a direction to file the report on the adjourned date and advance copies shall have to be served
Yes,
upon the
yes.
writ petitioner
has
by
not been
June
done.
23.
Yes.
It's not been complied.
My lord, may I hand out this report, my lord? This date back to the month of August 2023. This was the report which was initially prepared by the police. And my lord, there was another report pursuant to the direction of this honorable court. My lord, the report dates back to the month of December 2023. There are two reports. And thereafter, my lord, here is the report which was circulated by the learned additional district magistrate, my lord, Baharampur. My lord, that report was sent to me by this sealed envelope, my lord. This dates back to July 2024. So, my lord, what I was beseeching your lordship is that kindly gives me 2 weeks' time. I'll prepare a comprehensive report on affidavit and I'll submit before your lordship.
But
Because I
only
have
thing,
the reports.
but only thing, let the interim order at least maybe complied with. An interim order was passed as early on 16th October 2023. That is not being complied. A contempt petition is pending.
What interim order?
Pirate will kindly come to the order dated 16th October 2023. The third page, my lord.
16th October 2000.
2023, my lord.
Yes.
The third page, the second paragraph from the top, my lord, the last sentence. At this stage, while admitting the instant writ petition for hearing, the court directs the private respondents not to interfere with the pisciculture of the petition and the other rights in respect of 304 acres of field till 15th December 2023. This was extended from time to time and it's still valid. But this is being actively violated by the private respondents. We are not being allowed to carry on pisciculture, and the state authorities, including the police authorities, are actively colluding with them. This is the
My lord,
situation.
this is a very, my lord,
Where is the CPAN?
The contempt is pending, my lord. And, this was passed by Honorable Justice Vivek Chaudhary, my lord. Contempt is pending from this order.
So his lordship has been transferred from this court.
But it has to come, my lord. It has to go before the appropriate bench. No?
So have you taken any steps?
My lord,
Have you taken any
No.
steps for assignment? That I intend to know.
I have to take instructions from my learned that.
my lord, what my learned friend was just mentioning, my lord, pursuant to that order, my lord, here I have a copy of the report, which dates back to 12th December 2023.
What I've understood from your submission that at present you have 3 reports. in
Yes,
your
my
hand.
lord, I have 3
So
reports.
you have to make a
Comprehensive report. Yes, my lord.
So come back.
I was
How much
beseeching,
time you
my
require?
lord, 2 weeks, my lord, because the police are stationed at
Asuna.
Sagar Dighi, my lord.
What's your good name?
My lord, Ovix and VIK,
Mr. Sengupta.
Apologetic about this indulgence, my lord.
Very good, sir.
The fact is, my lord, the comprehensive.
I'm ready.
Absolutely, my lord. I'm extremely grateful, my lord.
Yes. Call the
Thank you.
next man.
Now for the respondents.
I appear for the petitioner.
You are for the state respondent.
Yes, sir.
State Railway,
Railway.
Oh,
Eastern
Railway Authority.
I submit one thing.
Give me a second, sir.
না
না, না,
এক্সটেন্ড
hearing,
হেয়ারিং এসেছে
hearing.
হিয়ারিং এসেছে
Railway.
এটা তো এক্সটেন্ড করা হয়ে গেছে
My health is not
So,
sound.
you are seeking an adjournment.
If your lordship kindly next week, my lord,
Not this week.
not this.
They have got the injection order, it continues. Actually, will not, ma'am, this is, I'm not opposing. I'm not opposing at all.
Not this week, next Friday. Next Friday.
Next.
Please come ready on that day, sir.
7, 8 and 9.
Same.
No, my lord. 9, my lord, I have some serious objection. Because of the fact, my lord, the person who has filed the writ petition is not the genuine person. On that, kindly see, my lord, the cost title and affidavit,
দেখি কি আছে?
supplementary affidavit.
No, 9, 8 not this week. Holo.
We're talking item 9.
9 with you are for the petitioner.
Yes.
after 2 weeks
Regarding, my lord, 9, I have some objection. Kindly see. And for this reason, particularly in this matter, my lord, I have filed an application for vacating the interim order. My lord, kindly see the first cost title,
Cost title of writ petition.
writ petition. My lord, Asimul Islam, son of, that was, my lord, rectified as nephew.
Nephew.
Then, my lord, kindly see the affidavit page.
Yes.
Page 16, my lord.
Son of.
Son of. My lord, this is the main thing. Actually, that Muzaffar Hussain, he is not his father, maybe his uncle. And originally, that land license was granted in that person who has died, my lord, the long back ago.
What license?
The land license of a land miner, of a railway land, so that they can carry out their business. And that was expired in the year of 2015. By manipulating some way, my lord, he is carrying out this business. And my lord,
So, sir, what
your-
is your contention then? But these
he
Asimul
has
Islam,
no authority to occupy this land, my lord. My lord, more surprising thing, your lordship, kindly see the supplementary affidavit.
supplementary affidavit.
Yes, my lord.
Affidavit reply to এটা দেখছি।
That was, my lord, that notice which was issued by another person, that which is annexed, my lord, in the supplementary affidavit.
There is no supplementary affidavit. I do not find any. But there is no supplementary affidavit. I do not
But,
find
my
any.
lord, we have served, my lord.
I will file any supplementary affidavit.
But we have served. Ziaul Haq by letter dated 13 August 2023. My lord, in that supplementary affidavit also, my lord,
No, sir,
Asimul
where is the
Islam, son
supplementary
of late Muzaffar Hussain.
Huh?
And my lord, that final removal notice, that was in the name of another Wasim Sheikh, son of Faizul Sheikh, Faizuddin Sheikh.
No supplementary affidavit is there.
But my lord, I have
report in the
served-
form of
kindly see my lord.
correspondence number 2 and 3 is there. একটু দেখো তো বাবা কোনো সাপ্লিমেন্টারি এভিডেন্স আছে কিনা এগুলো সব এই অর্ডার শিট গুলো আলাদা
Probably, my lord, that was filed, my lord, code number 10 before the Honorable Justice, my lord.
Can you
Ghosh.
tell me the which order?
My lord, at the time when, my lord, that interim order was passed.
আচ্ছা আমি জাস্ট দেখে নিচ্ছি I'm checking. Have you filed any supplementary affidavit?
I am not trace out it. my lord.
Anyhow, my lord, apart from that fact, I have also filed an application, my lord, for vacating the interim order, stating all the things, my lord. And my lord, the initially notice was served under the Public Premises Unauthorized Occupancy Act, my lord. And your lordship, my lord, well regarding that under section 9, provision of appeal is there. My lord, no writ petition is maintainable. And my lord, the land is required for the development purpose, and the railway board also issued the notice. My lord, due to this interim order, we are not able to, my lord, the start work, my lord.
Which order is under challenge, sir?
My lord, we are, my lord, also
Page number?
my lord, that in the writ petition. My lord, in the writ petition, kindly see, my lord, the prayer portion.
They want to set aside, they want setting aside of the
My lord, the eviction order, nil dated served on 10 August 2023.
where is that? Has that been annexed?
Yes, yes.
Show me the order. Page number 21. In excess of the powers on our author, public premises eviction of others. Have you got the book, sir? You have got the book.
Respondents, my lord, railway.
Book, act.
I have
Show me the act. Public premises eviction of unauthorized document act.
section 9, my lord, kindly see.
So 9 is the provision for appeal.
Then when there is a statutory appeal warrant,
Provision of appeal is there.
দেখি আছে
And my lord, particularly
এই দাও গো।
very recent days, our High Court 2 division bench judgment and my lord, the several single bench judgment. Section 9, my lord.
Let me go through the five
Yes, yes.
first.
হুম? কে ছাড়া হচ্ছে? দিও না।
License was originally issued to whom?
That Muzaffar Hussain.
Muzaffar.
In the year of 2010,
Then why in your report in parawise comment it has been stated to the petitioner? Page number 5 of your report.
my lord, I have filed one application, my lord. Kindly see that
You
can
have-
one,
you
my
have
lord.
also filed it.
Not, my lord, kindly see one paragraph from the statement. My lord, kindly see the paragraph 2, my lord, of the writ petition. Paragraph 2 of the writ petition. Page 2, my lord.
Yes, sir.
Your lordship got it, that
Yes.
paragraph 2. That your petitioner states that, in my copy, my lord, stated uncle
Here is uncle.
of the petitioner was the actual occupant of the railway line situated at New Farakka Station Road, Police Station, such and such, District Murshidabad, since 1977. Person age is 37. So, my lord, his date of birth should be 1980. আমাকে একটু বলে নিতে
Wait,
দিন,
wait,
sir.
wait.
So, person age is, date of birth should be 1986. My lord, he is, my lord, continuing business prior to that. And after the date of the father of the petitioner, my lord, it is very vital. The petitioner is running a hardware business over the said land. Earlier, your petitioner made several approach before the railway authority for lease out the said land in his favor. That after several attempts and after long time, ultimately the said land where the petitioner is running his business for selling hardware goods by constructing a paka structure which is not permissible, by agreement dated such and such, dated 12/7/2010, granted license in favor of the petitioner. Your petitioner accordingly used to pay the license fee, including other fees against the said licensee. Paragraph 3, that your petitioner said that since 1977, he is running his business. He is running his business for selling hardware business over the sub-leased out in his favor. In his favor. By the authority without any kind of disturbance and or without any kind of warning from railway authority. The railway authority,
Contention, the license was executed in his favor.
no, that is his contention.
His contention.
Yes, license was never executed in the favor of the petitioner.
So estate officer has been found, has found that he is not an a
Never.
lawful occupier.
Never. And my lord, kindly see the which agreement they have annexed. Page 17, my lord, kindly see page 17.
Yes.
My lord, kindly see an agreement.
Muzaffar Hussain.
Muzaffar Hussain.
So you prefer an appeal, why file the writ petition?
And my lord, for a moment, kindly see my lord, two documents I want to.
Appeal lies before the principal district judge.
Yes, yes. And your lordship had the first idea regarding that. And I have stated in my CAN application. For a moment, my lord, kindly see.
No, you have an alternative remedy, sir. You go there.
No. My lord, your lordship, kindly.
Kindly see my.
Yes, tell me. Take your seat.
My lord, regarding CAN, I want to say something.
Definitely, I will allow you. No. This order, which is passed under section 5,
Yes,
is an applicable under section 9. Then how writ petition is maintainable?
but in the writ petition, I have challenged the no notice was served. If notice was not served,
That can be that point can be taken up at in the appeal itself.
appeal, how will appeal?
The order is applicable one.
No. Lordship, your lordship, kindly consider this. It is the contention of in the writ petition that no notice was served, was not given any chance to.
Very good, sir. I understand your contention. In an appeal, every point is open. You can take that point in the appeal.
Kindly, your lordship, three matters is similar matter, my lord. Your lordship, kindly.
No, I will not allow you this. Take down.
Like take.
I shall keep the book for some time. You take it on Monday.
Yes.
It was item number কত ছিল ওটা? 9.
Not 10% I beg to appear on behalf of the petitioner. 10 and 11 are analogous matter lordship are relating to same. In earlier occasion, the matter was taken up on 16th April 2025. There is a direction upon the respondent to file a report in the form of affidavit lordship. They have that was communicated to us in lordship. Grateful. 16th April, the matter was taken up, and there is a direction upon the state to the state has filed a report on that day. So we have to take the exception of this report, and subsequently the respondent number 8 and 9, Lordship, they're supposed to file a reply, and we have to give the exception. There is 4 days to be given to us for that reply, Lordship. They have to supply. Now, Lordship, they have given this document day before yesterday, Lordship. We have received, but Lordship, that somehow
my
the annexures are day before yesterday. They give us the reply
My lord,
without
there is
annexure.
a mistake on my part.
The annexure.
The annexures.
8 and 9, who are they?
My
Private respondent?
No,
No,
my lord. They
Mr.
are
the
Gas
GAIL
Authority
India.
of
Gas
India
Authority of
Limited.
India.
Huh?
Gas
GAIL
Authority.
India,
GAIL,
Lord.
Authority of India Limited, my lord. GAIL, my lord.
GAIL, man.
GAIL.
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 Yes, my lord. My lord, the
Yeah, yeah.
affidavit was affirmed, copy was
Yes,
served on
answering
them, but I find, my lord, my junior had made a mistake. The annexures are not, my lord, served. During the course
Now
of
we have
today
received the
itself,
copy of the report.
We received the copy without annexure.
I'll serve today only, my lord.
And
Yeah,
even
my
you have
junior
served
has
the
made a
papers day
mistake.
before yesterday. It is
In service.
indicated
You are-
in
you are
the
filing.
order,
My
Lord.
lord, my junior has not annexed the annexures. He will prepare today, my lord. He will serve today. He will file today, my
So I'm making it not this week.
lord. Kindly
2
keep
weeks.
it not
Lordship,
this week. They
let
can
their
file
order
that.
be passed, Lordship, that in
Yes,
the
sir.
meantime they will serve.
As
this,
per
Lordship.
request made at the bar, let the matter be listed on July 25, 2025. Stop. Learned advocates for the parties are hereby requested to comply with the formalities as directed to be observed by this court on 13/6/2020.
Grateful, man.
Deeply obliged.
You understand?
Yes, your
In the
Lordship.
meantime, you will get the copy and you will file.
My lord.
Deeply obliged.
Grateful to your Lordship.
I believe Gail is the answering respondent. You do it in the meantime, sir. So that the matter can be taken up on that day. এটা কোনটা? ও সকালবেলা প্রিন্টিং মিস্টেক হয়েছিল, ইয়েস ইয়েস 12:30, ইয়েস।
My lord, I am praying for not today on behalf of Supratim Dhar appearing in this
Told
matter.
that his matter was not in the list, Mr. Thor, he has not come today.
নট দিস উইক করে রাখুন, পরে দেখছি তাহলে। নট দিস,
Not this week.
ইউ আর ফর দ্য পিটিশনার,
I am for the petitioner, my lord.
মিস্টার ভট্টাচার্য,
Private respondent.
Lordship,
what is the matter about?
my lord, proceedings,
Just one or two line.
proceedings, my lord, of my lord, section 5 of the my lord, eviction of unauthorized occupants act.
Section
No,
5.
West Bengal Prima, West, my lord,
What I was having, there's a proceeding 133 first.
no, that is not
That
that.
is their allegation because the government land. My client has acquired that portion of the land, is in occupation. They filed up to 133 proceeding that is still pending. They came to this Honorable Court. The Honorable Court directed the SDO
Very
to
good.
dispose the proceeding. Thereafter,
Come back on the next week.
West Bengal Highways Act, my
Highways
lord,
Act.
eviction order has already been passed.
or that is under the
That is to
National
be
Highways Act
implemented.
or West Bengal Highways
West
Act.
Bengal Highways
But
Act, my lord, that is already my lord
submission
implemented.
in the recorded right nature of the plot is Pukur. Pond.
Yes,
I can show.
let enter.
I can show the
If
record
it
that
is
is
Pukur,
Pukur.
my lord, let enter construction go. If it is Pukur, my lord, let enter construction go, my lord.
No, I
Already, my
know.
lord, already inquiry has been made.
10 for 4 order has been passed.
Yes, my lord, direction was given to my lord demolish the unauthorized
So that
construction.
the direction
So
was given.
petition is
That
for
is-
implementation of that
Yes,
order.
for implementation.
Yeah, for deep petition.
in the-
Your
What I am
contention,
saying.
My lord,
your contention is not a highway.
No high. Not high.
It is a Pukur.
Yes.
Rayati
In the
land.
record. Yes.
Rayati land.
Yes. Now I am saying my landless client's land is behind the back of my client's land. That is so much interested because that's not that's national highway 12. That is
It
so
is-
much interested.
It is my lord West Bengal State Highway.
If my land, if my construction,
Let
his client will be benefited.
come back on the
That
next
is true.
next Friday.
Okay.
11 কি আছেন?
10-11 তো এক না আমাদেরটা না।
11 তো ভুল করে প্রিন্ট হয়েছে বললে? হ্যাঁ? এইটা কিন্তু এইটা অর্ডার করেছি।
The petition, my lord. My lord, there was direction to file exception, my lord. But my lord, the petitioner's family members are suffering from COVID, my lord. So I have advised him not to come at this stage, my lord. They are in quarantine, my lord.
Not this week or not 2 weeks there?
2 weeks, my lord.
Fortnight.
Yes,
Ashun, as per request made.
I've got the state.
আর কিছু আছে urgent motion?
State. দাঁড়া দিচ্ছি আমি দিয়ে দিচ্ছি নামটা ভুল দিয়েছি
13.
Item 14, Your Honor.
13. You don't know, my lord. It has come to in your lordship, please, my lord. It pertains to my lord, education matter of 2025.
Wrongly printed. আগেরটা তাহলে কোনটা হলো 2 weeks যেটা
Kindly,
12 এ হলো তো?
my lord, kindly pass an order so that my lord, the matter may be released from your lordship list.
হ্যাঁ
তাহলে তো যাবে না তো ইয়ে। Wrongly print হয়েছে মানে
13 টা হবে না 9 13 wrongly listed.
my lord, kindly pass an order, my lord, releasing the matter from your lordship list. Otherwise, my lord, file will not go down.
There is no file on the part of the listing department. It has been printed. File is not with us.
Very good.
তাই তো আপনি ওইটা একটু দেখে নিন যে আমরা অর্ডার
Item number 14, my lord, I am the petitioner.
which was the state.
On the last occasion, Mr. Shantanu Kumar Moitro and Amrita Pal. On 21/6/2023, my lord, Honorable Justice Shubhra Ghosh directed upon the petitioners to serve the copy the direct respondent. I have served the copy.
Services be affected?
Yes.
How many private respondents are there? Ashun.
15, my lord, my lord,
15,
I
my lord.
appear for the state, my lord, if may I.
But if my lord kindly see the last order, my lord, I am also appearing for the state. My last day, my lord, kindly see, my lord, what has happened. My lord, and please to pass an order, my lord, on their intimation, my lord, that they had given me the intimation in my WhatsApp. I don't know, my lord, because I am carrying my phone.
Give me a second, sir.
And
Yes, what have you got to say?
my lord, on the last occasion, on the basis of this day, observation, my lord, the ILA department has been pleased to, they have, my lord, released me
They
from.
have released my lord, senior, my lord, and have engaged me. My lord, I have got the engagement now. Now, my lord, I am coming to know that.
My lord, even I have the report, I had obtained report on that day, my lord, I couldn't come being occupied in any other court, my lord, and perhaps in a division.
What's your good name?
Deepnath Rai Chaudhuri, my
My
lord.
lord, I have no problem if his appointment is regularized in the matter. We can both appear in the matter, my lord.
Notice cannot be served.
But WhatsApp they have said.
Serve notice upon the respondent state and his functionaries. But finding notice cannot be served, but finding no other, he has informed the learned advocate through SMS. আসুন
16 Lordship, I am for the petition Lordship, led by Mr. Boydurjo Ghoshal. Lordship, I am paid for short passover Lordship. So please anything good.
Passover. Very good Passover.
It's a huge one. Thanks.
I'm waiting for the petition amendment in this matter. Mr. Bandyopadhyay is waiting.
Yesterday,
Arguer will take time. What do you want?
Mr. Bandyopadhyay is coming, Millet. If your lordship be kind enough to grant Passover for 5
Passover, how many Passover?
Then let me start, Millet.
Start. Mr. Kausik.
yesterday your lordship had been pleased to deal with an issue of similar nature. Item 8.
This is altogether.
Item 8 yesterday.
This is the altogether.
Renewal of lease, lordship.
This is that renewal was pertaining to the Blackstone. This renewal pertaining to the granite. Now, so far as the granite is concerned, there is a specific provision which deals with it and which provides the renewal which supersedes the West Bengal rule. This is the affidavit of service.
I've dealt with 61 and 62 yesterday.
Yes, Millet.
It does not come under West Bengal minor mineral rules.
And in my humble submission, it does not because of the specific provisions contained in the rule itself, granite rule.
ফাইলটা দাও গো ফাইল ওখানে রাখলে আমি কি করে পাবো বলেন বাবু বলেন এই এসিটা একটু এসি বন্ধ করান না ঠান্ডা লাগছে দুটোই বন্ধ করে দিন
Upload হয়নি এখন। I think the order has not been uploaded. Yesterday's order.
It has been typed.
I was looking for that.
It was typed, it was corrected, but it was not retyped and it was not signed. That is
I was looking for that. All of us.
why?
My lord, kindly.
It has bearing on this matter.
Oh,
My lord, kindly come to page 34, Millet.
That is Blackstone is granite, my learned friends.
what is the case number? Can you
Yesterday item 8.
It was 11.
এই ফাইলটা আনা
11263.
এই হ্যাঁ আছে রিটাইপ হয়ে গেছে নিয়ে চলে আসুন না ওটা আপনি নিয়েছেন না নিয়ে চলে আসুন actually what happened they send it to my chamber I am to make necessary correction they have to retype it and in the 2 days afternoon we used to put signature so some time is required
Lordship.
anyway let the plan the case
My lord, kindly come to page 34, Millet first.
page 13
Page 34, Millet, 34.
34 okay, please. Yes.
My lord, this memo was issued on 15th of December 2004. Lordship will find at the right hand top, Millet.
This is the grant.
This is the grant. My lord, kindly see the point number 2.
Let me note, sir. This is a grant dated 15/12/2024.
2004, Millet.
I'm sorry. 15/12/2000. You are right.
My lord, kindly come to point number 2, Millet.
Yes.
You shall abide by the other general conditions as envisaged in Granite Conservation and Development Rules 1999. My lord, this is a specific rule which has been promulgated and introduced by the legislature regarding the mining of the granite. My lord, Mr. Bandyopadhyay.
Yes, yes.
No.
As you desire. Either you or he, whatever you like.
This lease was made in terms of granite conservation and development rules. That is the central rules of 1999. But As per rule 6, can we take the rules?
Annex করেছেন।
You have the book or take it from here?
Annex
No,
করা আছে, it is annexed, my lord.
Oh, annexed.
We'll have to start from page 177. দাদা 174 আপনি তো ধরেছেন মেশিন এখন
আরে এটা
কবে
করতে
থেকে?
গিয়েই তো মুশকিল না না
আপনিও মেশিন ধরে নিয়েছেন স্বাগত।
এর জন্যই মুশকিল হয়ে গেছে।
177
Can we take page 177? What is the rule? Kindly take rule 6. Page 178. Rule 6. As you can see.
Yes, sir.
Rule 6, period for which lease may be granted or renewed. The maximum period for which lease may be granted shall not exceed 30 years, provided that the minimum period for which such lease may be granted shall not be less than 20 years. That is also good. Rule 6, sub rule 1.
30 is the ceiling and 20 is the base.
Base. A lease may be renewed for a period exceeding 20 years.
Not exceeding.
Not exceeding 20 years, I'm sorry. Notwithstanding anything contained in sub-rule 2, if the state government is of opinion that the interest of the development of granite it is necessary to do, it may, for reasons to be authorized the renewal of a lease for a further periods not exceeding 20 years in each case. So renewal is for 1 year, one period, but if state government thinks it can be for successive period.
Yes, sir.
Now, kindly take rule 52 of that mark, page 184.
So then it is renewed for 20, thereafter further 20.
First is maximum 30, minimum is 20. Then one renewal is the rule 6(2).
For 20 years.
20 years.
With further 20.
That is the state decision of the state government. State government can make it successive.
Now, sir, which rule I shall see?
52, page 184.
Rule 52.
Yes.
Page 184. Yes.
Or applicability of the provisions of minor mineral concession rules framed by the state government. The provisions of the minor mineral concession rules or any other rules framed by the state government under section 15 of the Act shall be applicable to granite quarries to that extent that are not repugnant to or inconsistent with these rules.
The provisions of minor mineral concession rules are in section 15 of the Act. 15 of the Act means which Act?
Mines and Minerals Act.
Shall be applicable. Yes.
Development Act.
That is the Mother Act. Shall be
the Mother Act.
applicable to granite quarries.
Well, under section 15 of the Mines and Minerals Development Act, state government is authorized to frame rules. And these concession rules have been framed under this Act.
Then, sir?
Kindly take section 15. It authorizes the state government to make rules. Mines and Minerals Development Act is the central act. The rules, granite rules is the central rules, smaller because the these items of regulation of mines and minerals, smaller, this falls smaller under list 1.
List 1.
Only land part is smaller falling in the list 2.
List
2. Smaller now. In the case of the petitioner, the lease deed was executed on 28 July 2005.
Page 39.
Page 39 it starts.
Lease deed executed on
Uh,
28,
28 July 2005.
28,
28
28 July 2005.
for 20 years. My lord. Kindly take page 39. No, 20 years.
Yes.
Now, the renewal is not at page 91. That is in line with the this renewal clause 3, page 91. It's in line with rule 12 of 2002 rules, concession rules, for one period.
Yes.
Which stood repealed.
Which stood?
2002 rules has been repealed in 2016
Absolutely.
rules. Now, what the state government did, we applied within the time. The competent authority relied on rule 61 and 62 that it has not been saved. But they completely ignored the provisions of the granite conservation and development rules, which is still, which has an overriding effect. I have shown your losses rule 52 that anything inconsistent that will not be applicable. So granite conservation rule is still subsisting. The lease was in fact under granite because under the 2002 rules, lease could not be more than 5 years. Because it is under granite conservation rule, that is why lease was granted for 20 years. Under the state concessions rules, lease period could not be more than 5 years.
That I've understood.
Yes. Now, under the granite conservation rules, as I have shown from rule 6, it maximum 30 years and minimum 20 years. And it is renewable as per the parent rules, or the central rules. The impugned order, no hearing, nothing. Malad, kindly take the impugned order. Page 176. Page 176. No hearing, nothing. One 176 is the impugned order.
Minor minerals bar করে দিন
62.1. They had now shown 62.1.
Will you kindly place Mr. Bandyopadhyay page
62
number 176
of
the read petition?
yes, yes,
Memo under challenge.
Yes. Now, subject you also will find renewal of binding lease dated such as such in Torino for granite block situated plot number such. With reference to the subject, I am directed to inform you that applications of Torino for renewal of binding lease such and such have been considered and rejected in terms of sub-rule 62.1 of the West Bengal Mineral Concession Rule 2016. This is the only, nothing, no reasons, nothing. Absolutely cryptic order, no hearing. In fact, if we are given the opportunity of hearing, we could have shown them that I am covered by the granite conservation rules. Rule 62.1 the repeal, only repeal.
That I know. Lease deed was executed in the year 2005. It was initially for 20 years.
20 years, it is.
So it is going to expire on
To expire on.
27 July 2025.
Yes.
So within in the meantime, we have applied for renewal.
Yes, prior to.
So whether the maximum period for which any such lease may be granted shall not be less than 20 years. It will be renewed for not exceeding 20 years.
Or
So, Mr. Bandhavada, your contention is that they have overlooked the provision of section 6.
Rule 6. As well as Rule 52. In fact, if process permit, I may make one prayer because this order is unreasoned order. It cannot be sustained.
No, sir, that I understand.
No, only one thing,
Maybe I understand your contention. That when this rule says that the applicability of the existing mineral rules shall be applicable to the instant, except to the extent they are not repugnant or inconsistent with it. So you says that when this rule says the lease may be renewed for 20 years, so that inconsistency should not be considered in the perspective of these rules.
Absolutely.
That is your contention. I've understood your contention. Yes, Mr. Gali.
Lordship.
Let him pass a recent order.
Lordship, the reasoned order is a question of
Not
law.
required.
Not required, Lordship. May
How do you
sustain
justify
to justify this? My
section 52 with rule
Lordship,
62?
Rule 52, Rule 52 of 1919 rules framed by the central government. Rule 52. My first respectful answer to the submission of my learned senior friend is that mining is subject matter of list 1, or mining is also subject matter of list 2 also. Constitutional provision. It is subject matter of list 2 also. That's first contention. The Lordship comes to 7th schedule to the Constitution of India.
Constitution of
আপনি বলেছেন শুধু list 1, that's why I'm giving respectful reply to it. So many respectful reply, my lord. It is not only list 1, kindly comes to 7th schedule to the Constitution of India.
Just a minute, sir. Just a minute. 7th schedule, union list, state list. 229 পাতায়। আরে এসিটা বন্ধ করলেন না এটা? ও করেছেন, thank you. List 1 or list 2, I'll see.
First list is list 1.
Yes.
My learned senior friend has been pleased to refer to me, lord. Kindly say entry 54. Regulation of mines. Lordship got it?
Yes, sir.
Entry 54 of list 1. Regulation of mines and minerals development to the extent to which such regulation and development under the control of the union is declared by parliament by law to be expedient in the public interest. Now, my lord, may next, my lord, respectfully, my lord, invite your lordship, my lord.
Regulation of mines and mineral level to the extent to which development under the college
Parliament by law to be expedient in the public interest. Next, my lord, if I may respectfully invite your lordship, my lord, to list 2. State lease, my lord. Entry, my lord. 23.
23.
Lordship.
Yes.
Regulation of mines, my lord, got it. Regulation of mines and mineral development, subject to provisions of list 1 with respect to regulation and development under the control of the union. So it exists in both the list. Next query is, my lord, concession rules of 2016.
Yes.
My lord, concession rules of 2016, my lord, have been framed in exercise of the power, my lord, envisaged, my lord, under section, my lord, 15 of the Mines Minerals Act of 1957, my lord, framed by the central government. So 57 Act is a federal statute. So in exercise of section 15, state has framed 2016 concession rules.
Section 50.
Section 15 of 1957 Act.
Section 15 of the Act permits to frame the rules.
15, section 15
Exactly, I'm on that.
of the 57 Act.
Power of the state government to make rules in
Lordship.
respect of minor rulers.
Lordship.
Yes, sir.
So in exercise of section 15 of 1957 federal statute, state frames a rule in the year 2016. That is concession rules.
Section 15
Concession
and concession rules of 2000.
2016.
2016 rules.
It comes into effect with. It comes into operation with effect from 29th July 2016. It says in 62, Lordship already is very thorough with these two rules, 61 and 62.
Yes.
Rule 62 says the West Bengal Minor Mineral Rules 2002 is hereby repealed. So by operation of these subordinate legislation 2016, rule of 2002 have been repealed.
Yes.
Lordship. Now, my lord, may I respectfully invite your lordship to first the impugned notice that is at page, my lord, 176, which my learned senior friend has shown. What does the authority say? That we are here rejecting it in terms of Rule 62, Sub-Rule 1 of West Bengal Mineral Concession Rules 2016. So authority is invoking, my lord, concession rules, my lord, Rule 62. Lordship got it? Why? Because his agreement was entered into on the basis of 2002 rules. Prior to 2016 concession rules, there was 2002 West Bengal Minor Mineral Rules, which provided for renewal. So
give me a second, sir.
The agreement with him.
No, in the grant, you will be abide by the granite conversion and development rules.
I'm coming next. The agreement with him was under 2002 rules.
Lease deed.
Lease deed. Page 91 kindly sees the renewal clause which my learned friend is adverting to. This agreement starts from page 39. 39. So these agreement, because that time 2016 was not in vogue, lease was entered into in the year 2005. When 2002 rule was in existence.
No,
you got it?
I understand your contents.
Lordship. Now 91 says.
No, wait. In order to understand, you have to read the terms and condition of the grant order.
I am going.
Rule 1 says kindly come.
I will come to that, Lordship. Kindly, my lord, I will come. Very soon I'll be reaching that point. Very soon.
Very good, sir.
Very soon I'll be reaching that point. Now my learned senior friend is drawing your lordship's attention to the renewal clause of that particular agreement entered into in accordance with 2002 rules. What does it say? Page 91, renewal clause. The mining page 91. The renewal clause shall be renewable for one period, not exceeding the period specified in sub-rule 2 of Rule 12. Rule 12, sub-rule 2 of 2002. It is of 2002, not of Granite Rules 1999. There is no quarrel on the issue. Because state goes by its own rules. The 2012 rules
But if the rules is repugnant to the original rules, what will
that
happen?
even 2016 virus has to be challenged? Yes, of course. So 2009, page 91, rule 12. Rule 12 of 2002 rules provided for renewal.
Mr. Ghali, try to understand my question.
I'm answering to your lordship. If 1999 rules provides for renewal, why are you not giving the renewal?
Yes.
This is the query, my lord, of this honorable court. I will answer to it.
Absolutely.
So renewal provision in the lease deed is on the basis of 2002 mineral rules, not of 1999. Because 2002 mineral rules of West Bengal.
But the 1999 rules also provides for renewal.
Does not. I will show your lordship here and now. Now, my lord, my learned friend was referring to page 34 at the very outset, before the arrival of my learned senior. 34 is of 2004. 34 memo is dated 15 December 2004. Grant of long-term mining lease for exploitation of granite in so and so. I am directed to refer to the subject mentioned above and to state that upon due consideration, government has been pleased to order that a mining lease for exploitation of granite in respect of the under-mentioned area for a period of 5 years shall be granted to you, and on your complying with the following conditions and execution according to law within a period of 6 months. Terms and condition of mining lease as mentioned in Rule 21 of West Bengal Minor Minerals 2002 shall apply. That is first condition. Second, you shall abide by other general conditions as envisaged in the Granite Conservation and Development Rules 1999. Number 3, you shall submit draft mining lease deed in model form prescribed in the West Bengal Minor Minerals Rules 2002 along with the sketch plan showing plot details. So and so.
Let us come to the point.
So and so.
In
Now,
the event there is a contradiction between 2000 rule and 99 rule, which will prevail?
Well, in that even entire 2016 has taken care of. I am showing your lordship that provision. So after this document, page 34 has come this lease deed. Lease deed provided for renewal as per 2002 mineral rules. Lordship. Now kindly see rule 26, rule 16. Now kindly, my lord, may I respectfully invite your lordship to this 2016 rules. Kindly see rule 38. Kindly see rule 38 of 2016 rules. Kindly see rule 38, means grant of prospecting license comes so and so, so and so, so and so. The granting of prospecting license come mining lease for exploitation of mineral minerals shall be made through the competitive bidding, and separate rules shall be framed by the state government in Commerce and Industry Department for conducting competitive bidding through a notification. The grant of mining lease for exploitation of mineral minerals shall be made through a competitive bidding, and rules shall be framed by the state government in Commerce and Industries Department for conducting competitive bidding through a modification, provided that, I am on this, the exploitation of granite shall be conducted in the manner prescribed in the Granite Conservation and Development Rules 1999, with the exceptions made in these rules. With the exception made in these rules. What is the exception? 2016 rule, if your lordship goes to, does not provide for renewal of any kind of leases. If your lordship sees, my lord, rule 5, it is only for the period of lease, without there is no provision for renewal. So this proviso has been provided for, 1999 has been taken care of, but in the same breath, the legislature says that with the exception. With the exception. Now my learned
Granite Conservation Development Rules 99 is the central rules.
Central rules.
And the state rules.
The state rules. But here we are framing it in exercise of the power under section 15 of the central rules.
But that must not be repugnant to the.
If repugnant, then he has to test the repugnancy, my lord. He has to test the repugnancy, lordship. If it is repugnant, it has to be struck down. Then rule 38 has to be challenged. The virus that it is contradicting the repugnancy test, which my learned friend is trying to show your lordship by adverting to, my lord, kindly comes to.
No, that relief can be molded in the instant need petition.
Rule 52. Rule 52 of 1919 rules. Rule 52 of 1990 rules says applicability. The provisions of the minor mineral concession rules or any other rules framed by the state government under section 15 of the Act shall be applicable to granite quarry leases to the extent they are not repugnant to or inconsistent with these rules. Our rule says, with the exception made in these rules, it will be applicable. Now, if the repugnancy is, there is, it has to be challenged separately. The entire rule.
It cannot be questioned.
My lord, there is no repugnancy, my lord, as on date. Because we are having the absolute authority to frame the rules, where we have not provided for any, my lord, renewal clause. We have not provided for any renewal.
What I intend to say, that the rule 52 of the 1990 rule says that the provisions of the minor minerals of rule of the as framed by the state government under section 15 of the Act shall be applicable to the granite quarry leases. Am I correct, sir? To the extent they are not repugnant to or inconsistent with these rules. So, in the event, while disposing the instant writ petition, this court finds that this proviso is, for the sake of argument, this court finds that this proviso is practically contradictory to the rule 52. This court has got no power to hold that it is an unconstitutional.
Ample power, my lord. Yeah. But the challenge has to be separate. How it is repugnant? Because our lordship is referring to our proviso. Your lordship is referring to proviso to rule 38. Proviso rule 38. It says then a separate challenge has to be set up. There are no grounds in this writ petition. There are no grounds in this petition.
The court has the power to mold the relief.
In that even, I should say, my lord, it is not repugnant as because, my lord, we have the absolute power to frame our own rules.
Yes, sir. I understand. I absolutely agree with you. Subject to the condition of that rules. That is rule 9.
But no, lordship, but his agreement, lordship, kindly appreciates one thing, that it says that mining lease, lordship kindly sees.
To the extent they are not repugnant or inconsistent with these rules.
Lordship, mining lease is being entered into. Mining lease is entered into or was entered into not in accordance with 1999 rules. Mining lease was entered into, my lord, in accordance with 2002 rules. 2016 rule says that 2002 has gone by operation of 2016 rules. My lord, lease was not given in terms of, my lord, conservation rules.
Sir, what do you want? Should I refer the matter for reconsideration?
Can you relegate, my lord?
Or I will make an observation over this.
Will kindly relegate the matter to the, my lord, rejecting authority who has rejected it to throw some light on the applicability of 1990 rules in the present, my lord, aspect of the matter. Since it has not yet expired, prior to expiry of the lease, he has prayed for renewal. Let them throw some light on it.
Only one thing I
am
pointing out. Next matter.
To be very honest, I'm not so much convinced with your argument, Mr. Khalid, at least in this case.
254 answer is always any law made by the parliament will prevail over the state government.
Yes, only one thing. Kindly see his application for renewal. Once.
Where?
In my case, it is 139. The next case, same matter.
Same petition as same matter. Same issue.
Same issue.
Oh.
18টা দেবেন জজ সাহেব।
দেখি 18টা দিন।
Page 163.
এক সেকেন্ড।
163.
The present matter.
If the language is same, then no difficulty.
দিন কি বলছে দেখি কি বলছে
But what I am trying to submit is what submission is coming from the bar is not reflected in his application. His application is simply situated under 2016 rules and the terms.
Point number H, page number 165, point number H.
Just a second.
Point number H.
Kindly
in
see,
terms of the
he is referring to the agreement.
existing binding leases, renewable one period for another.
application for renewal of two numbers of one period
There are two lease deeds.
হ্যাঁ
The first matter is one lease deed and the
Yes, same this.
matter is another lease.
same date
Same deed.
আসুন আসুন
Kindly see, if he has not taken the point,
what point
the point of 1999 rules will apply in the application for renewal. My lord, what the poor officer will do? What is his
An officer is not poor who said he is a poor আসুন আসুন আসুন
Lordship only kindly sees that renewal clause entirety, page 91 and 92.
listen to my order
91 and 92, it says that renewal shall be done in accordance with
no
2000
I understand
Lordship.
And I am adopting the other submission made by my lord.
Mr. Galib is appearing আচ্ছা
Same in both the.
no both the dates are same
5th of May 1925.
আচ্ছা,
2020.
লিখুন July.
At least, that he continued, till 2 weeks after the decision. Otherwise, I cannot again come back and file.
Acha, আরেকটা লাইন অ্যাড করে দিন। It is while making such extension, it is however made clear that this court has made no observation with regard to the merit of the representation.
Any right.
Any right or equity,
And the extension
right or equity.
and the extension as granted by this court till the last day of August 2025 will not be treated as any right.
Any second session.
Yes, yes.
There is a pen down strike of the court officer.
Neither you nor we are a party. I will sit. It's only 2-5.
There is a resolution as well.
No, I will sit, sir. People are waiting for getting justice.
I'm not saying that, Your Lordship.
245.
Grateful.
245. Yes, call the list. देखिए दाओ.
With your lordship permission, may I be kindly permitted to mention? We have filed this new fresh matter.
Sir, first button your coat. Yes.
We have filed this matter and we are planning for inclusion in the list.
Within my determination, motion.
No, we have filed this matter, but it has not been included in the list.
It is in the motion stage.
Yes.
Are you sure?
Yes, that's what I have been informed by my senior.
Motion, it is in motion. It has been detailed in the list, the slip motion.
একটু দেখে নাও এটা আমার ডিটারমিনেশনের মধ্যে আছেন কি, তাহলে বাড়িটা আনিয়ে নেবে. How long you are practicing?
This is the first day of my High Court appearance.
First time. Whenever appear before a High Court, first button your coat. Okay, that is the decorum of our High Court. Very good. What's your good name?
Anirban Ghoshal. Anirban Ghoshal.
Anirban Ghoshal. Very good. Wish you all the best. দেখি ফাইলটা দিন. রিলিজ চাইছিল নাকি? You are appearing?
My lords, I appear because on behalf of the decree holder in item number 1.
You have made it has been listed at your instance.
That is correct, my lords. My lord, upon mentioning, it was indicated by lord that due to the this matter was actually left part heard. So due to the cases by you, I mean the backlog of the cases will be
Yes,
released.
yes. The writ petition is represented. It appears from the order dated March 20, 2025 that the instant GA2 of 2024 be treated as part heard. That the instant GA2 of 2024 be treated as part heard. Full stop para. In view of my heavy determination, it would be very difficult for me to take up the instant matter. For the present, stop. In view of such, GA2 of 2024 be taken off as part heard. Stop para. Department is directed to place the GA2 of 2024 before the honorable bench having appropriate determination.
Much obliged, your lord.
Release. তাহলে এটা লিখে দেবো. ভেরি গুড. কি লিখলাম একটু লাস্ট আগের প্যারাগ্রাফটা একটু ডিপার্টমেন্টের ওই আগের প্যারাগ্রাফটা বলুন. Be taken off from part heard, and the matter is released from my court. তারপর ডিপার্টমেন্টের উপর ডিরেকশন. Yes.
For the petition, this matter.
I appear on
matter, my lord.
number 1 to 6 minutes.
What happened? Here, my lord, petitioner is my lord the owner of the plot. I have annexed the document of my lord.
It's a new motion.
New motion.
Who is for the petitioner?
I am for the petitioner. Now here, what happened?
This matter, I appear on behalf of the full company. And today morning, my lord, respondent number 4 send this letter, my lord, kindly see. No copy of the writ petition received by the charge Victoria area, and as such they are not able to give
The
any.
copy has already been sub my lord, affidavit of
instruction,
service. Now, my lord, your lordships know the system. Unless and until I deposit, my lord, the affidavit of service, the filing is not, my lord, possible, my lord. My landlord is appearing on the company. I have served to the company. Now every officer, my lord, he is asking, my lord, that thing.
Actually, answering respondent number 4, my lord.
So, my lord, I have
Answering
served the company. Bharat Cooking has been served. way back in May.
But area, I mean, not respondent number 4 is situated in the West Bengal, and respondent number 1, 2, 3 is situated in Dhanbad.
Yes. So company
Different
has,
state. That is the separate area of the Bharat Equality.
company has been served.
And
Who is the answering respondent?
respondent number 4, my lord.
But I have served the company. Respondent number one.
Petitioner seeking for cancellation of the employment.
No, it's already on the record. BCCL has been served, and my learned friend, how my, I have, if I have not been served, how my learned friend can
They
appear?
made the party to the respondent, then copy to
No,
be
no,
served to all
no,
the
no.
respondents.
You are representing whom?
Respondent number 1 to 4.
Then how my learned friend can say?
You have a soft copy?
Yes.
You have a soft copy?
The hard copy is
Only
also with me, with
one
him.
copy has been served to the Bharat.
A soft copy I have served to him.
No,
Soft
the other
copy, soft
respondent.
copy, my learned friend asked my lord 2 weeks back. I can
Soft copy you have got?
Yes.
Yes, I have got on behalf of the respondent number 1, 2, 3.
Huh.
But actually answering respondent number 4. General Manager Charge Victoria area.
What do you want now?
I am paying only 2 weeks time to take instruction from the respondent number 4.
You have got the
The
copy
answering respondent. Yeah, I sent yesterday by mail.
along with all annexures.
Yes, my lord. Today only just written.
Well,
You have got the. What about the service upon the respondent number 6 and 7? It has been affected.
6 and 7 private. Yes, yes. I have served one of the affidavit of service.
Without appearing private respondent, his matter cannot be decided because.
Well, what can be done? But I have served to him.
Sir, not all at a time. Sir, wait, sir. Let me satisfy about the service. Thereafter, I suppose.
Kindly see. BLRO and my lord, the private respondent has been served and they have received.
How much time you require?
3 weeks, my lord.
What is your prayer?
My prayer here is, my lord, here what happened. I have the ancestral property. I have annexed the document. Now, my lord, the private respondents, my lord, clubbing my land, working in Bharat Coking Coal Limited. Here the policy is a person, if he is want to get the employment, he has to, my lord, satisfy to the authority that he having the 2 acres of land. Now,
Again, it is file order. Order book.
first time, my lord.
First time?
Yes.
The affidavit of service to check on record করতে হবে আচ্ছা আসুন
He asking for cancellation of the employment of the private respondent.
Very good, sir. I shall consider on the next day. If possible,
But
on the
no
adjourned day, come with a
copy of the appointment letter has been annexed. When he has been
He
appointed.
will suffer. Call the next man.
Not only that, my lord. The copy of the deed.
Sir, make your submission on the next day.
Grateful, my lord.
Call the next matter.
Grateful.
Who is appearing? দেখি ফাইলটা দাও হ্যাঁ ফার্স্ট কল করবে সেকেন্ড কল করবে মানে ঠিক আছে নেক্সট
Number 4. Number 5. Number 7. Number 8. Number 9. Number 10.
Means, Madam, I am appearing on behalf of the plaintiff, my lord. This is suit of 1930, my lord.
from this side.
My lord, this is a suit of the year 1930. 1930, my lord. In this suit, my lord, the parties have settled and the property relating to the trust, my lord. Scheme is framed by the Honorable Court, my lord. Time to time, on the basis of the scheme, my lord, we are seeking
So you want to
various.
withdraw?
No, my lord, with the should may kindly be out of list, my lord. Liberty to mention as and when necessary orders to be sought for by the parties, my lord. Because, my lord, on the basis
What
of the
is the
scheme,
stage of the suit?
stage of the suit, my suit is settled, my lord. On the basis of the scheme as framed by this honorable court, on the basis of that scheme, my lord, we are seeking time to time various directions as well as the seeking permission to administer the trust, my lord. So, my lord, what I am praying before your lordship.
Suit for administration of
Yeah,
trust.
yes, my lord. What I am praying before your lordship, my lord, to out of list the matter, my lord, and liberty to mention as and when necessary.
Next. না ঠিক আছে আপনি 13 চলে আসবেন এটি রেডি আছে লয়ারটা
But I appear for the respondents, madam.
Who is for the petitioner?
Mr. Banerjee, Arindam Banerjee.
Where is he?
Possibly, my lord.
Yes, sir, for Puri or Goa.
Not today. In the last occasion also Mr. Banerjee was not there.
My lord.
On the last occasion Mr. Banerjee was also not there.
No, he was there. Last occasion, आपने तो कुछ
Possibly, my lord, I came late.
Oh, be there sir, not today. 14.
My lord, in this matter, learned Advocate General Kishore Dotto is appearing on behalf of KMDA, my lord. On his ground, my lord, I am praying for not today, my lord.
On the occasion you are praying for accommodation on the ground of
My
Advocate
lord,
General.
only this not today.
এই কি আছে ফাইল
On the last occasion, my lord was pleased to reject the pending GA application and my lord fix the matter for final hearing because otherwise it's ready for hearing. Parties have exchanged, my lord, all their affidavits.
Where is Mr. Talukdar?
Talukdar is on his leg before code number 24, my lord, I think, as it has been informed by him.
What is the read for?
The writ petition is, my lord, challenging the alleged acquisition, my lord, conducted by the state under Act 2. My lord, Act 2, my lord, is
Act
the
of 1945, 48.
48. Now, my lord, on behalf of KMDA, my lord, the land was acquired. My lord, my challenge is, my lord, the acquisition which has been done.
Then who is for the state?
my lord, state Mr. Mahato was appearing, if I am not mistaken. Now, my lord, all the parties have exchanged their affidavit. My lord, upon my contention is, my lord, the Act 2 provisions have not been followed. My lord, first. Second, my lord, on the, my lord, documents which have been relied upon, my lord, it will be evident the state authorities have himself, or the land acquisition department himself has supplied a notification. Those lands, including my land as plot number being mentioned, are not for no more required for the requisition purpose. Therefore, this should be released. So, my lord, there was a circular to that effect.
Acquisition done.
Acquisition, my lord, section 4 notice issued. But, my lord, there is a circular saying that if you do not require the land, return the land. Not required. My contention is, my lord, before issuing section 4, section 3 not compliant.
Section 3 compliant.
Not compliant. This is my point. Acquisition itself is bad.
Section 3 is the acquisition.
Absolutely, I bow down.
Section 4 is the requisition.
No, my lord.
I'm sorry. Section 3 is the requisition.
Section
4 is the acquisition.
So,
So which has not been completed?
Section 3.
No notice was published.
No governor order has been passed.
Does not gazette.
No, no.
Gazetted.
It was gazetted.
Four, yes. 4 gazetted.
It was gazetted.
3 not gazetted. The act contemplates, my lord, as far in the affidavits, my lord, there is no disclosure to that.
It is complete, my lord, if your lordship fix the matter for hearing.
Already fixed, sir.
I'm only 2 days accommodation, my lord.
Not today. Sir, only one day I keep it for original, sir. Why are you taking adjournment?
My lord, is this sudden
That
difficulty?
ground is will not be persuasive on the next day, I am telling you.
Oh, next day up, I will make submission, my lord. Definitely.
A lawyer remains busy in another court is no ground for adjournment. See the civil procedure code.
My lord. My lord.
Call the next matter.
Obliged, my lord.
I am appearing on
Well, I appear for the
petitioner,
response.
Your Lordship. May I file the affidavit in opposition to the affidavit, sorry, affidavit in reply to the affidavit in opposition filed by the respondent number 6. It was served to the respondent number 6 within time, Your Lordship.
Yes.
Seems the respondent number 6 is not here.
Who is the answering respondent?
Your
Oh,
Lordship,
Kolkata Municipal Corporation mainly the answering respondent because it is relating to the building plan. It is relating to the building plan. But the beneficiary of the building plan which is asking for.
The respondent number 6.
Respondent number 6 is the private respondent.
You are challenging the
Cancel-
sanction pack which has
cancellation
been obtained by the respondent number 6.
Yes, Your Lordship. And during the pendency of the writ petition, it was again revalidated, modified by the respondent authority, which is why my challenge before this honorable court.
Nobody is interested. Who usually appears on behalf of the respondent number 6?
Devnath Ghosh, the senior advocate.
Times,
He is
but
representing.
on the last few occasions, he was not appearing. So maybe he is appearing. Someone else was appearing. Maybe he's here in the matter.
No, last occasion, 4th April, Mr. Devnath Ghosh.
He appeared.
With Dutt Majumdar, Mini Agarwal, they appeared.
Yes, they appeared on the last occasion before us.
The affidavit in reply as filed today. Take down. The affidavit in Second call. ফাইলটা দিন, ফাইল দিন, অর্ডার বুকটা দিন। অর্ডার বলে কিছু নেই, এরকমই হয়, এরকম হয়। লিখে নিন, the parties are not represented. কে নেবেন? The parties are not represented. Same order.
At number 6.
Same order.
Number 7.
Same.
Number 8.
Same.
Number 9.
Same.
Number 10.
Same.
And number 12.
Same. কল্যাণবাবু কোথায়? পেন ডাউন আছে, চলো তাহলে। কোথায়? Item number? এখন আছে তো আপনার সাইড? Only original side? এখন